Hello friends, welcome to the first series of Ask Me Anything. This series basically relates to the legal issues of the startups. So, what are the issues that the startup are facing nowadays, or how can that be resolved, or what would be the mitigation point, and how can they create a value after resolving these legal issues? So we are discussing for next for our next couple of minutes. We will discuss about these issues and the resolution point of that. Uh, I would request or I would like that the session should be a more interactive, so you can ask me any questions, any doubts that you have in your mind, so that I can give a proper resolution of that, or I can try to mitigate. I can try to give you a proper solution for those issues. So before starting the session, let me introduce myself. Myself, Sandeep Chandra. I am partner at Alpha Value Consulting, and I am heading our legal vertical over here. Our firm is into a transaction advisory, legal advisory, and in the valuation advisory. So we are connected with many startups, and on a day-to-day basis, I am facing this kind of issues that the startups are facing. So. Then an idea came to my mind that why should not we should start a series in the name of Ask Me Anything. So first we started with the legal issues, because in the name of if you see that in many of the cases we only focus on our some creation of some tractions or creation of a value creation we are talking about, and how the idea, how much is a successful idea. So that is altogether important, or we can say that the key function or key area, but as well as the legal point, which we consider that is the trivial issues. But these issues on a later on can become a bigger issues in the time to come. So why not we should start mitigating, and why should not we start to take a proper action, to take a proper mitigation solutions to resolving, so that the adverse effect on those issues in our operations, in our day-to-day working will be less or least, we can say. So, before going into nitty-gritty, I would like to hear from all of the participants over here, and you can drop your questions in the chat box, or you can directly ask the questions to me eh, about your doubts, about your we can say that whatever you have in your mind related to the regulation. So I have received some questions from the participants, and I would try to answer those questions over here. So the first question that I received from Shakshi, that is related to how to start a startup. So I think she is basically talking about or asking about the structure of a startup company. Or we can say a startup. So there is no foolproof formula, or we can say there is no any foolproof mechanism that the startup should be started in this way. But if you have any idea in mind, if you have a proper, you are executing or you are working on those ideas, and you think that this idea can be a market hit, or you are solving any problem, or you are giving something to the society, and you want to commercialize that idea, so in that case you should start your own business. So it's a basically business term which is relating to the business. So if we say that startup is a particular thing, or a particular area, or a particular structure, that is not the case. But in case if you want to take your idea to the next level, then you should go for the prevailing structures in the market. So what are those prevailing structures, like the registered partnership, or a limited liability partnership, or private limited company. So the on the other side, if you say that the government is also promoting the organized or organic structure, or this type of structures, because in this type of structures, it are more transparent and more legal compliant, and the government can take any view on that, and the government can incentivize those structures. So, in order to start your startup, coming to your question, then if you have a registered a partnership firm or a registered partnership firm or a limited liability partnership or a private limited company, then in that case, the normal formalities that you need to comply with for the registration of these firms. Uh, MCA on the MCA portal or through the MCA route, you can select your name or you can reserve your name, and after reserving your name, you can file the documents. Then within a week's time, you will have your corporate structure ready. So after registering your firm or your company with the MCA, then you have to file with the DPIIT for the registration to recognition for yourself as a startup. Because in the DPIIT, you will have to give your details as well as the full proof idea and the statement and how it will benefit the society and the detailed profile. So after recognition of your startup, whenever the DPIIT gives you a recognition, a day's time that DPIIT will give you a recognition, then you can claim that you are a startup company. So then you can project yourself in the market as a startup, and you can circulate and you can work upon that. So before starting any LLP or a company, you need to have your founder or co-founder with you, because OPC concept is new in Indian market, but the OPC concept is not acceptable as a startup company. Uh, However, some people use this way, OPC way also, but that is not a fruitful in the market. And after that, after registering with the DPIIT, you can take the benefits of the startup under the Startup India scheme as well as the Invest India scheme, and the stand up startup take the grant, or you can get an incubate. You can register yourself with an incubator as a incubating company, where you will be provided all kind of mentorship as well as uh, to for scaling of your business, to scaling up your idea, as well as to scaling up for your we can say that scaling up of your to take your ideas to the next level. So in that case, after incubation, then the accelerator model is there, and you will get the benefit of the fundings as well as to get the funding from the investors if your idea is good. So the initial level, the startup will be started. I would recommend that the startup should be started as a LLP or a company format. And after that, I got a question from Mr. Samir Verma that is to related to his startup. He's saying that I am running a gaming startup, and presently there is no business in that startup. What all components are required? So this is the basic, we can say, the illusion amongst the startup companies or the founders. So what they thought that I need not to comply anything, or I need not to take any legal action, or need not to comply any legal thing, because I am not running any business, or my business is not. I have just incorporated a company or incorporated a startup, and that's it. And the startup is somewhere else, but no business activities going on. But in that case also, you have to comply with minimum statutory compliances. So what are the minimum statutory compliances? Because that depends on the nature of your business, nature of your registrations, as well as the nature of your activities. So, firstly, in the gaming industry, if I say it's an online gaming industry, if I say that you must have contact with some escrow agents, you have appointed a trustee also. Then the trustee, on the mutual agreement basis, you have to give information to them on a monthly basis or a quarterly basis about the activities that you have done in a particular month or a particular quarter. Because in this case, gaming industry, or online pooling of money is also involved. So the escrow agent or the escrow person who is pointed way you also seek some information from you on time to time basis. So you have, even if you have not done any business or not done any, you do have to report to those person on a monthly or a quarterly basis. Apart from that, if you have registered a company, in that case you have to comply the company law rules. So what are those company law rules? Those are company law rules are that you have to file the annual filing firstly, annual filing, and basically comply with the board governance or board meetings you have to conduct, and you have to show the board meetings over there, as well as to file the various returns like with the deposit return, that is the annual compliances, or annual return, to file your financial statement with the ROC, as well as to KYC, your directors didn't KYC compliances, you need to do that. But apart from that, on the income tax front point of view, if I say that the income tax point of view, if you have any employee or employees running, you have employed the person, then in that case you have to uh, pay the salary. If you are paying the salary to them, then you have to deduct the TDS, and you have to file a TDS, quarterly TDS statement, annual TDS statement, as well as the income tax return. So, apart from that, employee provident fund, if your employees are more than 10, then you have employee provident fund, or the labor law is applicable on you, where you have to minimally, whether you are doing any business, whether you are not doing any business, it is immaterial with respect to the statutory compliances. So you need to do the statutory compliances, however bare minimum statutory compliances, so that you can run your company smoothly, and you can avoid the penalties, fines that has been prescribed in the various statutory acts or the laws. For example, if you are not filing any annual return or with the MCA, or we can say the ROC, then in that case you, for the late penalty of rupees 500, rupees, sorry, rupees 100 per day, you have to pay. That penalty is getting accumulated on the period of delay or the number of delay. So it become a hefty amount, even 1 lakh, 2 lakh, we can say any amount of the penalty that can. Similarly, in the case of labor laws, you have to pay them additional interest, additional penalty. Even in the some of the sections of the company law also prescribing the prosecution against the person, against the defaulters or wrongdoers. So in order to avoid all such kind of the things, you need to be synchronized with the laws, whether you are operationalized or whether you are not operationalized. So it does not matter. If any founder say, or if any founder thinks that okay, fine, I'm not doing any business, I'm not doing, I need not to comply anything, or I need not to file anything with the uh, authorities or the statutory authorities, they just keep mum on. Then if they do not follow these regulations, then ultimately their company can be struck off or voluntarily by the government, because the government is taking a hard step on those companies who have not filed their annual final statement for last 3 years. So you have a buffer period of 3 years, or either you can file or you can get your company stuck off. Then it depends on the funders. But complying is a better recourse, or complying is a better option, instead of just keeping mum on those kind of things. And the next question that I am making, that is asked by Mr. Deepak Gupta about the tax incentives. That what are the tax incentives that the government is offering for the startups? This is very critical, I can say, the area about the tax incentives, that because everyone is talking about the taxes. So if I start this thing, if I do this thing, what the incentive that government is providing to me? In that case, I may differ from the querist that startup is not get the benefit of taxes. Startup is just to start your business and to employ the people and to take some innovation, or to introduce a new technology, to introduce a new innovation, or if you have any innovative idea on that, to promote that idea so that can the life of people can be better. We can say the ease of living. So the startup concept is basically to promote that ease of living. If you have any better idea, if you have any lucrative idea in your mind, you have started your startup, but if you are concentrating yourself that only I will only start the business if some government is giving me some incentives or some promotional kind of things, then that is not a good idea to do do it. But however, government is providing various tax incentives in order to promote the startups. So, what are the tax incentives? Because in order to promote capital funding, in order to promote employment, as well as to promote the start ecosystem, healthy business environment, the government is, however, in offering some tax incentive. For example, if any startup is registered within a 10 years, or we can say the startup is not 10 years old, then the tax holiday for 3 years is provided to that startup. But however, that startup is required to be registered with Central Board of Direct Taxes for that exemption, to avail that exemption. But many startup are not in such a position, or does not care about the registering. But that is a rider. There is a rider over there. So incentive is there, but that is subject to fulfillment of some conditions, some riders. If you are falling on that criteria, then only you will be able to get the tax incentives. Apart from that, if any startup is scaled up and idea is very good, and the government is thinking that this startup is doing a fantastic work, so in that case, some foreign investor is going to put our money. But in that case, or we can have foreign or angel investor, we can say that an angel investor is putting a money in your startup, and you are getting the money on an amount of valuation, or any amount of valuation. In that case, it may happen that you have to bear the angel tax, but from that angel tax, the government is giving the exemption subject to fulfillment of some conditions. So, what is the angel tax? Means when the money is received more than the fair value of the shares of the startup company. If the fair value is less, but you receive the more amount, then in that case, the additional amount you will have to pay the tax. So otherwise, you have to give a merchant bank report. But if you are registered with the CBDT to take that exemption, or for that exemption, then in that case, we can say that you will be exempted from angel tax. So basically, these are the two kind of incentive, but I don't think so that the incentives will be very helpful for starting any business, or starting any idea. But if you have an idea, if you can say that your idea is a market fit idea, and it can give you ample of amount, or can solve the problem, and can do the ease of living to the people, then you should go. For your business, not worrying about the tax incentives what the government is offering. However, the government is offering on that point of view. The another question that I received from Ginny Rani. So she's talking about what are the probable pitfall that a startup at a seed stage should avoid. It's a very interesting question. So I think that the seed stage, before going the seed stage, that is a progressive statement, I must say, because they want to check the things, that what are the things they should not do, so that at the seed stage they would have any problem, or getting into any litigation type of. So in that case, firstly, whenever any startup or company is going for a seed stage funding, so to my mind that at that time, the investor looks after the promoters, if inquire about the promoters, their background, or about their conviction power and their experience and about their education and experience also. So in that case, if we can say that what would be the pitfalls, so those pitfalls are firstly the investor will check about the chemistry between the founders. So, what is the chemistry? So, who is taking the lead? Who is the final decision making authority? Are both the promoter or how many promoters are? These promoters are the both the founders are the decision making authority. So, who will do what? Because in the seed stage funding, the investor invests in the idea or in the promoters or founders, not in the business, because at that time the business might not get generated some traction. So in that case, the founder's background and founder's decision making conviction power will be checked out. So sometimes it happens that one founder is saying one thing and another founder is saying the another thing. So there will be a conflict of their decisions and conflict of their idea. So in that case, how to mitigate that thing? So in that case, you firstly have a founder's agreement about that, because then the founder agreement is clearly joined on, clearly giving the responsibilities of Mr. X and Mr. Y, what Mr. X will do, what will Mr. Y will do. So, if Mr. X is a tech person and Mr. Y is a finance guy, then it means that Mr. Y will talk about more about finance. He will focus more on finance, and Mr. X will focus on the technology and the product development and all the things he can, because he knows technology better and the Y knows the finance better. If both are entering into one another's arena, then it will be adversely affecting on the overall business of the company. So in that case, so my mind that the you should have a written document, or you should have a, uh, uh, clear understanding between the founders. So that clear understanding may be the type of founders agreement and a mutual understanding, and that can be incorporated into the charter document of a company or a partnership deed. So the roles and responsibilities are clearly defined. Investor would like these things also. Apart from that, uh, if you are, because in startups, I have seen that most of the people used to say that I will just only taking care of my business. That is required. That should be the idea. But other things my consultant is taking care of, or my CA will take care of, and the CA is taking care of the uh, mm, compliances or the legal issues, whatever the information is providing to him. So in that case, I say that continuous flow of information should also be given to the consultants, so that they can uh, trigger the point, or they can comply the things if there are any legal issues arise. For example, if uh, balance sheet has been prepared, but in the balance sheet if there is something happening, for example, the salary of the founders have been increased, but in that case there is a no board approval, or no shareholder approval has been obtained, then in such a case, then the approval can be taken. Then in the next board meeting or the next shareholder meeting, the resolution regarding the approval of for increasing the salary of the founders or the promoter can be moved on. So this is a small thing that I have narrated over here. Apart from that, if any payment has been made or any new vendor has been enrolled, but there's no document for enrollment of those vendors, that will be that thing will be come into point whenever there is a some due diligence is happening, and at that time it may be considered the payment has been made to any vendor is unauthorized, or unauthorized payment, or that payment illegal payment, so it can be treated as that. So In order to plug in those things, the continuous flow of information should be given to the consultant so that they can document these things in their repository, or if there is an agreement needed to be drafted, that agreement can be drafted, or an email can be needed to be drafted. So the proper backup of that transaction, or the for proper backup of the documentation can be maintained. So whenever there's at the time of happening of this seed funding round, proper due diligence is carried out by the investor, so that he he wants to ensure, he or she wants to ensure himself that my money should not be used in such kind of things, or paying the penalties, or paying fines, or other things, or paying taxes. So my money should be used for the business purposes, so that I can uh, make a multiples of that. So such kind of the nitty gritty, like a founders agreement, every legal agreement should be in a place. Apart from that, if there is any uh, proper compliances of laws, whether it's a labor law, whether it's a company law, or whether it is a income tax law, proper return should be filed. If there is any delay, that delay should be explained. If you have already a foreign funded company, then the RBI is coming into picture, then in that case you have to comply with the FDA regulations, FDA laws. If there is any ambiguity, if there is any discrepancy in following those laws or obligations, then you have to bear the file. So, in order to plug in these things, all such kind of documents should be ready. But I also suggest that before they coming in for their due diligence, you should internally check your document and plug the loopholes, and to take the necessary action and take the resolution or mitigation of the problem. So, in that case, the seat funded, or we can say that person who is coming into the cap table, he will be more happy and see that the company is fully complying all the legal issues, all the laws, as well as they're more transparent and more corporately governed company. So, in such kind of the companies, the person be happy to invest in. So, because he will be rest assured that my money should not be wasted in such kind of fines, penalties, or other kind of things also. So the another question that I received from Ms. Nancy, that is about the uh, uh, shareholders agreement, that if any person wants to put a money in my company, and what are the things that I should be taken care of while entering into an agreement. So in that case, I would suggest that your consultant or lawyer will look into those things and note those nitty gritties, as well as the agreement, shareholders agreement, entering into shareholding agreement is basically a commercial term, and it is depends on the commercial things only, because that is a commercial decision that will be taken by you and your investors. So whatever the negotiation that you should do with your investors, that should be done on the table, that should be settled on the table. uh, However, the basic things that you should keep in mind, that about your dilution of the capital, how much you want to dilute, and what kind of the voting right, and how many voting right you want to give to those investors, if they are asking about the as well as the cap table, that if they are asking the differential voting right by putting a major amount of money, then you have to take a call on that, whether you are ready for those things or not. Apart from that, right of first refusal is a main core area, that if you are offering the shares to the another investor, not only this investor, to the another investor also, then what will be the right of the existing investors, and existing investors should not be at a loss position. So everyone want to ensure that the firstly shares will be offered to whom, about tag along right, and the drag along right. If the investor is saying that if you are exiting the company, then what will be the tag along on tag along right of the investors, as well as the your other co-founders or shareholders. And about the management also, that the decision making power, who will keep the decision making power, because in the board structure will be decided between the investor and the company, we can say the founders. So who will do what, who will be the chairman, and who will appoint the directors, how many number of directors would be there, so that majority of the voting right would lie with the existing promoters or the existing shareholders. So these kind of the things, or these kind of the clauses should be put into the shareholders agreement. Apart from that, if there is a dispute, then how the dispute can be resolved, or the exit clause, how the exit, because the investor is more focused on the exit. So whenever the exit will be provided to the investor, and how that exit will be provided, what will be the mechanism, what will be the formula at which that the investor will be rewarded. Because the investor sometimes seeks that I will want, or I wish to get this X amount at the exit, while I exit this business. So that exit clause, or the formula for determining and taking into consideration the present business model of the company, that should also be negotiated with the investors. Uh, Apart from that, we can say that rights, authorities, but even the main things, that the banking authorities, about the authority in the banks, that's the crucial area. Sometimes it happens that when we talk about the giving the banking power, so sometimes the person says that the CEO would be mine, and every information or every financial transaction should be informed to my CEO, or my MD, or any kind of thing, so that they can take a proper decision whether to go ahead with the transaction or not. So in that case, it may create hurdles, or it may create obstacles in the day-to-day running of the business of the company. But that banking, about the banking power, that can be negotiated with the investor, so that it can be a good win-win situation for both of the parties. I got another question from this is Mr. Ahmed Patel. Yeah, Mr. Ahmed Patel. He's saying that he's running a, yeah, Mr. M. He said that he's running his startup, but there is a dispute among us, the founders, and how to resolve that dispute. So dispute relating to the operation and management of the. So in that case, Mr. Ahmed, I would suggest that firstly you should try to negotiate between yourself, and you should both come on the table, and you should decide about the next course of action. So courts are there to decide your dispute. If you have any founders agreement, if you have any written document between you, the dispute resolution mechanism will be uh, decoded over here. But if it is not decoded, then I would suggest that you should firstly negotiate, come on the table, and decide among themselves, and to try to resolve the dispute, so that because this is not only one case, you can also work for long term. You thought think about the long term, not on the short term period. If you are unable to resolve it through your mutual negotiation, then you can take NCLT route or file a case in the NCLT. If you feel that your interests or if your rights have been oppressed, then you can adopt relief. You can take a relief, apply for a relief under operation and mismanagement, and you can fight in the court, and then the court will decide about that. If you have a dispute ADR system, alternate dispute resolution system, then you can come on the arbitration tribunal, and you can go appoint an arbitrator, and the third person will award uh, you the give you the award after hearing you both the side, and that is the simplest way. Arbitration is the simplest way. But for that way, for enabling the arbitration clause, you uh, need to have a written document, or you have to mutually agreed about that. But at the end, I would suggest only that you should negotiate firstly between among themselves. If any assistant or need we arises, then we are here to help you out in your uh, resolving the disputes. So another question that I received from Mr. He has not written a full name, and but he has written only Mr. Srivastava. So I have got a question from Mr. Srivastava about the valuation part, that the how the startup is valued, but in the legally binding valuation. So it is a legally recognizable. If there is any law regarding the valuation, that how much valuation should be there in the start. So frankly speaking, Mr. Srivastava, the government has not prescribed, or there is not any law or regulation which is giving about an idea of the valuation. If you say that the if I say that the law has prescribed that the valuation of the company should not be more than this amount or that amount, that has not been prescribed. It is a purely a commercial decision, and it derives on the business synergies or the GTM, we can say go to market or marketable idea, about the marketable idea. How can a company can perform? Company may perform well or company may perform bad. That is another question. But if it performs well, then what will be the valuation? That valuation is solely dependent on the projections as well as the conviction of the management, how the management is comfortable regarding the to achieve the things. We can say that to turn the results into the turn the numbers into the results, sorry, turn the numbers into the results. So on that basis, the valuation of a company is decided. But however, some commercial methods have been given about the valuation, but that method has not been decoded in any law, but that is the market practice, or uh, we can say in the general parlance, the market practice or in the market that are prevailing in the method. For example, some are taking the DCM method, comparable company method, net asset value method. That the different methods are prevailing. But however, in FDI rules or ODI rules, we can find about the methods of the valuation. That is also taking the internationally accepted principles or internationally accepted methods that have been prescribed. So, what are the internationally accepted methods? The internationally accepted methods are given uh, only these. So, this is a main core. We can say that if we say that the government has given or the law has prescribed any valuation point of view, or that this valuation should not be more than that amount, that has not been given in any of the area. So if you have any another question, then I am ready to take. And this is our first series of Ask Me Anything, and the more series would come. So with this, I would thank you all the participants, and in the next series, we will talk about another topic. And I would like to hear from you about the topic so that we can share our knowledge on that topic with you. and we can resolve your problems. Thank you very much for participating over here. Thank you.